Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this live legal educational content, and today may be the day that I earn your subscription. For today's coverage, we're going to be covering the answer from the U.S. Soccer Federation in the ongoing lawsuit from the women's national team regarding equal pay. Last time we covered the initial appeal, so we covered the women's arguments in the appeal, and my overall conclusions were that the Equal Pay Act claims remain dumb, but there might be some chances for Title VII claims to be reversed. So that was or at least my tentative conclusion last time. So we're going to read this, and we're going to see if it changes my tentative conclusion as we see the arguments develop. So that will be interesting for sure. So let's get started with this. The United States women's national team is the best women's soccer team in the world. The women's national team should get equal pay for equal work, as all women should. The United States Soccer Federation is firmly committed to that principle. During the time period in question, the Soccer Federation paid the women's team more than the men's team overall, more per game, and more per dollar of revenue. And the Soccer Federation supported the women's choice to elect a compensation structure different from the men's team. That is what the district court rightly concluded, that the women's team did not even establish a prima facie violation of federal discrimination law. So why are plaintiffs claiming they did not receive equal pay? The women's team argues that some of the players would have earned more under the men's collective bargaining agreement, based on how the women's team performed. But the women's teams deliberately negotiated for a collective bargaining agreement that prioritized guaranteed salaries and substantial benefits over higher contingency bonuses. Right? Plaintiffs cannot now, with the benefit of hindsight, pursue equal pay claims based on different pay structure that they explicitly rejected. The district court agreed. This is not a factual dispute. It's not. No one really disagrees on the facts. It is not a battle of experts. It is a fundamental disagreement about what the equal pay means under the law. We're off to a promising start. And although the district court did not decide the issue because it held the plaintiff's claim fail at the threshold, the reason why the men's team has potential for higher bonuses and the reason why some of the women's players would have made even more under the men's agreement has nothing to do with sex. The men have potential to reach higher bonuses because they have potential to bring in more revenue from their competition. Right? Market realities. For example, in 2018 Men's World Cup, which is organized by FIFA, it paid the winning federation $38 million for the men's championship, but only paid $4 million for the women's championship, which is just above 10%. So yeah, that kind of makes it a little bit hard to have equal pay when the men have a much bigger prize pool. $4 million versus $38 million. We literally can't pay you like $20 million women team. There is not enough money unless we take it from the men. You know, economics. The massive gap in prize money accounts for more than 90% of the bonus differential. U.S. Soccer Federation is a powerful advocate for the growth of women's soccer worldwide and continues to lobby FIFA to narrow the gap. But the law does not require the Soccer Federation to pay the women's team tens of millions of dollars in phantom revenue it never received. You can't get blood from a stone, as they say. You can't get what we fundamentally don't have. Plaintiff's legal position in this case is unprecedented, untenable, and unworkable. The law does not and should not require female employees to accept the same compensation package as their male counterparts, or vice versa. Yet that is the very real consequence of plaintiff's position. If different is inherently unequal, no matter how much women make and no matter what they negotiate for, then employers will have no choice but end negotiations with carbon copy agreements. The equal pay should not take away women's bargaining power. The court should affirm. Yeah, so this is a nice little kick in the teeth for the women's team and their entire argument. Because what you're literally saying, women, is we should have had the men's deal. So what you're saying is you said we wanted a different deal, and the Soccer Federation should say, no, you have no independent power to negotiate. No independent power to negotiate. We don't care what your needs are. We don't care what your concerns are. Women have no place at the negotiating table. You just have to take the men's deal. But we have different concerns. We have different needs. Well, too bad. Take it or leave it. No negotiation. Because that would be the alternative, right? If people have the power to negotiate, they may wind up with unequal things at the end. So the only way to make sure they're equal is to take away their negotiating power. Yeah, so you want it imposed on you. That's an interesting concept for, the idea of women's independence over here. Just saying. We're going to force you, no matter what you want, to take the men's deal, rather than let you choose for yourself. Okay, that seems odd. The United States Soccer Federation is nonprofit. Its core purpose is to pursue growth of soccer in the United States for all players of all genders, ages, abilities, and to further development of players, coaches, referees, and administrators. As part of this mission, the United States Soccer Federation fields more than 20 national teams. These include youth, para-athlete, futsal, and beach teams, as well as senior women's and senior men's. As the national governing body for soccer, the Soccer Federation must ensure it has financial capacity to execute its obligations under the law, to serve all of its members, and plan prudently to grow the sport for years to come. Yeah, that's the basic mission of a nonprofit, right? We have a mission to our business, like every mission. Every business has a mission to its business, and fundamentally, it's to spend money properly and ensure growth and execute the mission of the organization, right? We want to grow, we want to be prudent with our spending, and we want to fundamentally accomplish our core mission of making soccer wonderful in the United States. Yeah, that sounds exactly right. The United States Soccer Federation first fielded a women's team in the 80s, and the women's team won its first World Cup in 91. Over the team's history, the women's team has been enormously successful, winning 4 World Cups and 4 Olympic gold medals. Not so much with the men, incidentally, who continue to need help. United States Soccer Federation takes pride on the success of the women's team and how the team has spurred the growth of women's soccer domestically and around the world. I'm sure it has. Plaintiff Megan Rapinoe has credited the Soccer Federation for its role in the team's success, telling the press in July 2019, which was during litigation, "Our federation is a case in point of funding the team well. Obviously, I'm the first to step up and fight with them and nudge them a little bit more, but they have backed us tremendously. Compared to every other federation in the world, I don't think it's even close." I believe that. I believe that the women's team is more supported by national soccer than any other women's team anywhere. I believe it. I think it's a big reason why we've been able to be successful and dominant as long as we have. We don't often give them kudos, but that's definitely one I'm willing to give. They back our team in a very strong way and have pushed the game, not only in our country, but around the world, to a level where, without that, we wouldn't be here in the world game. Right? So I think they deserve a tremendous amount of credit for that, and we continue to nudge them forward. Okay. To fulfill its mission to grow the sport of soccer, including women's soccer, the Soccer Federation must earn revenue. That is helpful for every business, profit and nonprofit alike. United States Soccer Federation receives no funding from the United States government. Instead, most of its revenue comes primarily from 3 sources: prize money and other payments the Soccer Federation receives from its team's participation and success in international competition, that is, matches and tournaments organized by other entities, ticket sales and other revenue from events, and returns on broadcasting, sponsorship, and marketing agreements. We live off prize money, ticket sales, the merch, and, broadcasting agreements. That is how we fund ourselves. Yeah. The women's and men's team represent the United States in international soccer. The teams compete in different tournaments with different revenue potential. The most significant tournaments are the men's and women's World Cup. Each World Cup is played every 4 years, and each has the potential to generate prize money for the soccer federation. That prize money is determined exclusively by FIFA, and based on the amount of revenue FIFA earns from each tournament. While women's soccer continues to grow in popularity, particularly in the United States, men's soccer has considerably more viewers worldwide, you don't say. Over 2 billion people watch the Men's World Cup. And because the Men's World Cup generates substantially more revenue for FIFA, right? Because FIFA's taking a cut of everything. So they're also getting a cut of, all those, broadcasting agreements and all those merch agreements and all that stuff. So that's, how they get funded, right? And also the contributions from the teams who have to pay as well, right? Because the men's team generates substantially more revenue, the gap between FIFA pays federation for participating in the two tournaments is staggering. For example, FIFA paid nearly $400 million in prize money to participating federations in the 2018 Men's World Cup, while only paying $30 million to federations for the Women's Cup. So here we're not talking about the numbers we talked before was what the men and women could have earned from their participation in the U.S. Now we're talking about worldwide, the total amount of earnings for the world. So all the men in the world who play soccer, all the men in the world who play soccer had the potential to get $400 million of revenue. All the women in the world who play soccer had the chance to get 30. Those seem like somewhat different numbers. And FIFA paid 4 times as much prize money to federations who merely qualified for the Men's World Cup, $8 million, than it did to the winner of the Women's Cup. So again, some of this is due to how FIFA does its structure, right? Because it pays different rewards. So FIFA says, we'll give you $2 million if you win the World Cup for the women. We'll give you $8 million for winning the World Cup if you're the men. This would be in addition to apologize, not winning the World Cup, I misspoke. For qualifying for the World Cup. So $2 million to the women for winning, $8 million to the men for qualifying. The prize pools are distinctly unequal. During the relevant period, the men team had the potential to play in several additional competitions. The Gold Cup is every 2 years, organized by whatever, and can generate $1 million in prize money. Some other thing, which is every 1 to 4 years and organized by someone else, pays that winning federation $6.5 million. And some other thing, which is held every 4 years and organized by FIFA, could generate $4 million. The senior men's team does not play in the Olympics. Okay. The women's team plays in non-World Cup competitions too, but none that generate prize money for the United States. So not only do the men get paid for winning, the World Cup and its tournament, they also get paid for winning other kinds of tournaments from other things. There's not only the World Cup. It's obviously the most notable, but it's not the only thing. The men play in other things, and those things generate money. The women also play in other things. Those things generate no money from FIFA. It might generate money internally within the soccer federation, but it doesn't generate any money coming in from the outside. So, zero is kind of hard to split. And, yeah. For instance, the Soccer Federation created the She Believes Cup, and I hate the name, incidentally, to give the women's team an opportunity to play in friendly round-robin matches. The matches that the women's teams plays in other tournaments, like Tournaments and Nations, are likewise classified as friendlies by FIFA. They generate no prize money. The Soccer Federation also hosts post-World Cup and post-Olympic victory tours if the women's teams succeed in those tournaments. The women's team plays in the Olympics every 4 years, but the Soccer Federation doesn't receive any revenue from that. And whatever puts on a regional women's competition each year, which doubles as Olympics or World Cup qualifying tournament, but that also pays no prize money. So yeah, you're getting the sense here, right? It's not just because they're women versus men. The economic realities of the two sports are very, very, very different. The amount of people watching the game is very, very different, not only live, but through television or otherwise. And that kind of like pretty much dictates everything, right? Because how many people watch the game, whether in the stands or on TV, dictates everything. It dictates ticket sales. It dictates merch sales. It dictates broadcasting rights, right? Because the number of eyeballs is going to be, more ad revenue, right? More eyeballs means more ad revenue, which means there's more money, right? So yeah, everything's dictated by basically how many people watch this. Well, not everything, but a huge percentage of it. And the women's teams in the U.S. and especially everywhere else in the world are just simply not as popular as the men's teams. So unless you can force everyone to watch the women's team just as much as the men, you're going to have a problem when it comes to the revenue. It's just not there. We can't distribute the no money. The women's team and men's teams have separate unions or player associations. So, as the name suggests, they are different teams, right? They're different teams in the same way that the Patriots and Baltimore are different teams. Yeah, they're different teams. They're under a common federation like the NFL, but different teams. To collectively bargain with Soccer Federation over terms and conditions of the employment. The Soccer Federation recognized the women's team as the women's players' exclusive representative in the early 2000s. The women players are the only voting members of the women's national team, and at least 2/3 must agree to any collective bargaining agreement. Because they decided to unionize and negotiate separately, the women's team and men's team enter into different CBAs at different times. So, they could have joined a common union, but, for whatever reason, they didn't want to, which is their prerogative. They want two different unions, one for the women and one for the men. Okay. I mean, that's an option. Means you're going to negotiate for different things, right? Presumably. The Soccer Federation pays the men's players under the collective bargaining agreement under a pay-to-play model, which means that players are paid only when they make the team roster for camps, matches, and tournaments. Specifically, the men's agreement provides for per-game payments, depending on the strength of the opposing team and whether the men win, lose, or draw. The men's team does not receive guaranteed salary. They do not receive any benefits. And they're not entitled to play in any set number of games. If the men's players are injured or if matches are canceled, they are paid nothing. The men are only paid if the games happen. The men are, under the men's agreement, the Soccer Federation has no obligation to play any person or even play any game. It would be counterproductive to the Federation's goals, but strictly speaking, under the men's agreement, they don't have to they could say, you know what, we're just not into soccer this year. Sorry, guys, we just, we're into volleyball now. I don't know, but they could do that. And the men would get paid zero. They're not required to look for any number of games. They're not required to field any player. No player is guaranteed field time, ever. If they get injured and disabled, too bad, so sad, no money for you, right? But that's what the men wanted. So, okay. All right, that's an option, I guess. The women's team, when negotiating, the women's team never asked for the men's team's structure. From the first proposal, the women's team made clear the women's team wanted more guarantees and less risk. Among other things, they want at least 27 players under contract, meaning guaranteed salary. You're going to get paid no matter what happens. They also want benefits like injury protection, severance pay, and childcare. The two sides negotiated within that framework. In one counter proposal, the Soccer Federation explained that it increased the guaranteed compensation at the expense of non-guaranteed compensation, which would be like bonuses, right? You get more guaranteed at the expense of the non-guaranteed. That's the point of the guarantee. The Soccer Federation also increased the number of contracted players, but stressed that this was a significant change, right? More players with more guaranteed salaries, more guarantee means less on the back end. But they stressed that was a significant change, and the women's wanted to accept a lower number. They would be willing to look at some other issues in a different light, right? So if you want this many contracted players, then, we want this on the back end. You want this much. If you want this much more, we want more for ourselves on the back end, because we're taking upfront risk, Pawn Star style. We're taking all the risk here, right? Because we have to pay you no matter what. What do you mean by no matter what? Oh, I don't know. What if a pandemic were to strike? That would be the example of whatever what. How much did the men's team get paid last year? How much did the women's team get paid last year? The answers to those questions would be zero, and distinctly not zero. On to other key aspects of these negotiations was the Women's Soccer League, a new professional league proposed to the Soccer Federation to grow the sport that would start in 2013. This followed earlier attempts to establish a women's professional league, each of which failed after a few seasons. The women's team sought assurances the Soccer Federation would subsidize the women's players' participation in this league, and the players would be financially protected if the league failed. So they're like, oh, we want to play more soccer games. We want, franchises, kind of like the NFL. And the Soccer Federation's over here like, but we've tried that before and it's failed because it's not popular enough to keep it running. And it's like, yeah, we get that. So we want you to fund us, and we want you to protect us if it fails. These might be very reasonable things to ask for. But, everything has a price, right? It's like, okay, you want all those things. We know we're having to shill out so much money, right? We have no guarantee, incidentally, that you'll bring in any money. See, for example, last year with the pandemic, right? We have no guarantee you'll bring in any money. We still have to pay you no matter what. We have some real liabilities over here. So if you want all that, we're not going to give you as much as the men do for the we win or we die. That's the men's deal. The men's ideal of healthcare is we win or we die. That's what the men want. The women are not into that. These seem, to my mind, at least possible choices someone could make. So I suppose the operative question is, should the women be allowed to make that choice? Because again, remember, see earlier, if the women's team and men's team have to have the same contract, it necessarily means they can't negotiate separately. So you've just taken away their ability to represent themselves. Seems counterproductive to my mind. In 2013, the women's players voted unanimously to approve the agreement. The agreement required the Soccer Federation to maintain 24 contracted players, to pay them a guaranteed salary, to pay them for a salary in playing the Women's Soccer League thing, and to increase the players' women's salaries if that federation folded. The contracted players were provided benefits like severance, injury protection, maternity leave, and medical insurance. And the players were provided bonuses for winning friendlies, which incidentally, remember from our earlier discussion, paid no revenue, right? So they're getting money for winning friendlies from which there's no revenue from FIFA or any other international soccer effort, but they're paying for it anyway. Money has to come for it somewhere. And the Women's World Cup, as well as payment for victory tours. The collective bargaining agreement placed no number on the limit on the number of non-contracted players who could be called up and placed on the roster, but those players were entitled to per game fees and certain bonuses, kind of like the men. Finally, the collective bargaining agreement included a provision ensuring the women's agreement would never receive less of their revenue than the men's team if the ratio of compensation to the amount of soccer federation generated from the teams fell below the men's ratio. The soccer federation would pay a lump sum. So they had this wonderful little catch-all clause just to get there. It's like, we want, on top of all the other guarantees, we want a guarantee that the percentage of total revenue, we want a guarantee of total percentage revenue. If we get more than that, great. But, if we get less, for whatever reason, for all these payments, if all they amount to less of a percentage of all the revenue than the men, you have to pay us the difference, right? So we literally didn't bring in the revenue, right? We literally didn't bring in the revenue, but we want to ensure that you're paying us the same percentage. That's what the women wanted. Okay. I mean, that's a lot of guarantees. Now, to my mind, these seem like reasonable choices. In fact, even looking backwards with the benefit of hindsight, I don't know, man. This looks pretty attractive. The women, I think, got themselves quite a good deal. I'm not so sure about the men with the, if I'm not sure about the men's proposal of, if my leg breaks, just take me out back and shoot me. I'm not sure about that as their health care plan, but, okay, all right. In 2015, they instituted negotiations for a new CBA. In its opening offer, the women's team sought to increase the number of contracted players. We want more guaranteed salaries and salaries for this soccer league. They also asked for comprehensive childcare and other benefits and requested the same bonus structure and bonus amounts as the men's team. No, that's not gonna fly, right? Because the men are getting bonuses, right? They're a pure play to pay or pay to play. They're a pure commission, right? They get $0. They only win through commission. And the women's team is, we want salary and their bonuses. It seems like the women might want unequal pay for them, though. In May, the Soccer Federation responded by offering a pay-to-play proposal with the same structure as the men. It's like, all right, well, you want the same bonuses, so the only way we can do that by the numbers is to give you the same structure. So here's our proposal, women. How about you adopt the men's deal? No salaries, no salaries for this soccer league, no health care, no child care, no money, just pure commission. We're not required to put you on the field. We're not required to look for games. We're not required to do anything. You want that deal? That's what the men wanted. Here it is if you want it. The proposal bonus amounts were lower in absolute dollars, but it included bonuses for tournaments that the men's team does not play in and does not have prize money in. Yeah, so the women were able to earn bonuses for things that they were doing, which didn't bring in revenue, like these events, right? Because the men also play games outside the World Cup. It's just that there's international money that comes to the United States for those games. So the United States gets international money for FIFA's World Cup and like a whole bunch of other competitions. For the women's team, they don't get any money. There's no revenue coming in externally from the world for all these non-World Cup games. But under the agreement, they're proposing to pay you anyway. Pay you for the things that don't bring in revenue. I mean, that's a possibility. The women's team said the players liked the structure of the proposal, but also needed a minimum guaranteed salary. Okay, those two thoughts don't go together in the same sentence. You can't say, I like the structure and I want a guaranteed salary. No. Counsel for the players explained that the men's players work in different environments, which makes pay to play more difficult. Okay. The players accordingly did not submit a pure pay to play proposal in response. Their counter proposal instead asked for guaranteed pay, this time for 30 players. So we went from the Soccer Federation's proposal of how about 0 to how about 30, and other benefits, and same pay to play compensation and bonus system. There is literally not money to make this happen. There is not the money to make this happen. It's impossible. The Soccer Federation explained that while we certainly support the concepts of equal pay, equitable and fair play, your proposal goes well beyond this. No joke, right? Because the men weren't getting that. Right? The men weren't getting any benefits. They weren't getting guaranteed salaries. We want 30 guaranteed salaries. The men are over here like, we're cool with 0. Yeah, that's not exactly equal. Yeah. In July of 2016, the women's team reinstated players' demand for the same pay per game compensation as the men's team. Okay, but also made it clear they did not want every other aspect of the men's team in agreement. These women are making all women look bad. I just have to say at this point, these women are making all women look bad. It should not take I took Econ 101 and 102 in college. Not a lot of econ classes, but, I understand the concept of there's only so much money in the pool, and we literally can't do that. You're asking for the impossible. The only way for us to do that would be to steal from the men's pool. But you're separate teams, remember? So we can't do that. We can't take from the men's pool because you're separate teams. And, the men would have to agree to it, and, probably not so much with that plan. It seems unlikely. But, they're like, oh, we want all these benefits, and we want 30 salaries, and we want the same bonuses. These women are making women everywhere look bad. It's like this defies all reason. I know a lot of smart women. I know a lot of reasoned women. This, it just seems blatantly unreasonable. As the plaintiff, Christian Press, explained to the Soccer Federation, the player's first guiding principle was guaranteed compensation for being a contracted player. Okay, you kind of have to choose between first principles. You can't have two first principles, right? So your first principle is either we want guaranteed salaries or we want the men's deal. You can't have both. They're literally in contradiction with each other. The parties also specifically discussed the World Cup bonuses. The then Soccer Federation president explained that paying the men's bonuses would financially break the Soccer Federation because it would commit the federation to pay out exponentially more than it would receive. We don't have it. It's not there. They also know the Soccer Federation had paid the women's players the full amount of their FIFA prize money plus more in the past. We are not cheating you out of the money that's available. We're taking all the money and we're giving you more. They say that women can have it all. Not this time. I mean, no man can have it all. No woman can have it all. You got to make choices, man. You're allowed to make choices. You're free. Or are you? Because are the women allowed to negotiate is still a toss-up, given the women's construction of the thing. The only way to make this work in practical reality would be to merge the men's and women's team under a single collective bargaining and single pool, and strip the women of their independent autonomy. So, yeah. The two sides reached a deal in 2017. The women's player voted unanimously for it, and the plaintiff signed it. A player and a plaintiff who also participated in the negotiation, Megan Killenberg, praised the deal, telling Sports Illustrated that we were able to get exactly what we thought was fair and what we thought should be in the CBA. We didn't feel like we were ready to go pay to play. I mean, okay. I mean, who am I to tell you what you want? Especially if I don't know you particularly well, right? Who am I to tell you what you want? I can be like, here's the trade-offs. Here's the advantages, but you know, if you don't want pay to play, cool. I respect that choice. Like the predecessor, the collective bargaining agreement guarantees annual salaries for contracted players and additional salaries for the soccer league thing. The contractors players' base salary increased to $100,000, and the soccer league salaries increased to $62,000 to $67,000. The bargaining agreement also provides that if the women's league thing ceases to exist, the contracted players' salaries must increase by 50%. And it pays non-contracted players camp fees, per game appearance fees, and bonuses. Sounds like the women are doing okay over here to my mind. I mean, it sounds okay. The 2017 bargaining agreement provides for higher annual bonuses too, though not as high as the dollar figures promised to the men. It provides for a set annual payment to the women's team to license the team's rights, as well as greater revenue sharing in the form of partnership bonuses tied to increases in television or other revenues, and requires the Soccer Federation to provide comprehensive packages of benefits, including severance, pregnancy, maternity leave, medical, dental, childcare, and a 401k. The 2011 agreement expired in 2018, but the Soccer Federation continues to compensate the men under the terms. The 2017 women's team will expire on December 31st of this year. The Soccer Federation is currently in separate negotiation with both teams. The Soccer Federation has previously offered to compensate teams under a single agreement, right? So we'll give you one common agreement that would give you equal pay. But to date, their players' associations have declined. How interesting. Soccer Federation has also offered both teams the same compensation deal. Negotiations yet remain ongoing. Okay. So let's talk about this lawsuit. In April 16, 4 class representatives filed charges of discrimination with the Equal Opportunity Commission. They declined to bring charges and issued plaintiffs a right to sue letters. So you have to go to EEOC first. They can either pursue it themselves or they can say no, but here's a letter, go for it, if there's anything plausible. Which, I'll give them plausibility, even though ultimately it doesn't go anywhere, but sure. Then in 2019, 2 years after the players' agreement approved it, all current members of the women's team brought suit. They alleged the Soccer Federation paid them less than the men's team in violation of the Equal Pay Act. So they were unanimous in agreeing to the CBA and also unanimous in saying the CBA is no good. They also asserted pay discrimination claims under Title VII, which look more promising initially, but we'll see if we change our mind as we go further, on the theory that they were paid less favorably than similarly situated male employees. In 2019, over the Soccer Federation's opposition, the district court conditionally certified a collective action under the Equal Pay Act and certified damages and injunctive relief classes under Title VII. The Equal Pay Act period runs from 2016 to the present. Title VII damages runs from 2005 to the class certification date. Both sides moved for summary judgment. Plaintiffs concede the district court had to consider all the players' various forms of compensation, not just each pay component in isolation. So they said, yeah, you have to consider everything. But plaintiffs nevertheless argued they were compensated at a lower rate of pay than the men because the bonus amounts in the women's deal were lower than the men's deal. Economics, man. And because the women, as a team, would have earned more during the period if they'd been paid under the men's deal. To support this prima facie case, the plaintiffs presented testimony from a single expert, Dr. Cook, who calculated the players' back pay damages by plugging the actual performance into the men's deal and subtracting out what the plaintiffs earned. I'm not sure you really need an expert for this. It sounds like basic adding and subtracting, but okay. Based on the calculation, Dr. Cook concluded the women's team would have made about $63 million more under the men's team. I'd like to remind everyone, just in case we've forgotten, that the Women's World Cup brings in $2 million for the winner. They also get paid for other things, other semis and things like that. So not only $2 million, but the point is still made. And they get paid a little bit for some of these external things. But they say, oh, we're entitled to $63 million. From where? It's not there. The money does not exist. More than 90% of these back pay are attributable to different World Cup bonuses. You think? The Soccer Federation, in turn, presents undisputed evidence the women's team earned more in total compensation than men, nearly twice as much. The Soccer Federation also presented undisputed evidence the women's team earned more per game than the men. And the Soccer Federation presented undisputed evidence that the women's team earned more per dollar of revenue generated by the team. So they had a higher percentage than the men. In addition, the Soccer Federation presented experts from a labor economist, Mr. McCarthy, or Mr. McCrae, who showed the 2011 agreement was not facially better than the two women's agreements. You can't tell on their face which is better. And the Soccer Federation arguably argued that any pay differential was fully explained by factors other than sex, namely differences in teams' potential to generate revenue and the team's different priorities in negotiating. I mean, it's kind of the ball game, right? I mean, it's like there's not the money. You guys want different things. We could force you to want the same things, I guess. Not sure why that's good. In a 31-page decision, the district court grants summary judgment to the Soccer Federation on both the EPA and Title VII. The court held that plaintiffs failed to establish prima facie case of unequal pay and accordingly did not consider the other arguments or affirmative defenses. The district court first held the plaintiffs did not carry their burden to show the Soccer Federation paid them wages at a rate less than the rate it pays wages to employees of the opposite sex. The court recognized the undisputable proposition that all forms of compensation must be included in the wage rate. This is true from the case law. All forms of compensation must be considered. And based on undisputed evidence, it found that the women's team were in fact paid more than the men's team during the period on a cumulative and average game basis. The district court rejected Dr. Cook's contrary methodology as a matter of law, concluding the plaintiff could not establish unequal pay based on what they would have made under the men's deal. Such an approach, the court explained, ignores the realities the men and women's team bargained for different agreements which reflect different preferences. So I suppose the women team have to ask themselves, are different preferences okay? Are you allowed to want different things? Because if you want different things, you can't have the same deal. So are the women allowed to have their own preferences or not? I mean, yeah. The district court next rejected plaintiffs' attempt to establish the women's team were paid less than the men based on certain statements. Even if the soccer representatives had said that women's players are paid less, the court reasoned that would not make it true, whereas here, the Soccer Federation presented evidence that was not paid less. So apparently, at some point, someone said, in the Soccer Federation said women are paid less. And the women were like, aha, admission. Which it is, I suppose. But then the court, admission makes it admissible, right? It makes it evidence. So yeah, you can admit it to evidence, but the court's over here like, well, they might have said that, but that wasn't true. I'm looking at the numbers right here. So the guy was wrong. Yeah. Finally, the district court grants summary judgment on the Title VII claim. Because plaintiffs did not demonstrate a triable issue that the women are paid less than the men, the court concluded they could not show adverse employment action. I'm not 100% sure on that one, as I mentioned before, but we'll discuss that more as we get there. The district court's granting of summary judgment on the Equal Pay Act and Title VII pay discrimination claims should be affirmed for either of two reasons. First, the district court correctly held plaintiffs failed to meet their prima facie burden to show the women's team was paid at a lower rate. It is undisputed the women's team made more in total compensation in the aggregate on a per game basis and as of dollar revenue. And the women's team and men's teams agreements are not facially unequal. The terms of the agreements are different, with some terms benefiting the women and others benefiting the men. This is not the rare case in which total compensation masks a facially unfair pay structure. They want different things. How can you determine which is better? By looking at it. Is it obvious which is better? Oh, by the way, you would have to say this before you knew the numbers, right? On the face of the agreement. That's the question we're asking, right? So, are the agreements on their face, is one inherently better than the other when you don't know the numbers, right? Because that would be the point. That would be the point of discrimination, right? That would be the point of the time of the discrimination, when the deal was signed, right? I mean, that's when it occurred. So, all you know is what you knew then. So, given what you knew then, which is a better deal? I don't know. Both sound pretty reasonable to me. The women sound like they're getting a pretty good deal to me, actually. The contrary argument is without merit. Plaintiffs critique the district court's total compensation standard, but fail to provide a doctrinally coherent or workable alternative. The total compensation is mandated by case law. Okay. They barely defend the standard they advocate below, the only one that was supported with expert evidence. Plaintiffs primarily advance a standard they previously conceded was not a correct view of the law. Well, it's a question of law, so they can change their mind, right? It's not a question of fact, so they can be like, actually, we think the law means this now. Okay. And they press for some kind of performance-based approach without providing a sound methodology, without pointing to any evidence in the record applying this amorphous standard, and without acknowledging that the women's team was paid more based on the key performance metric of revenue generated. And plaintiffs' argument the express terms of the bargaining agreement demonstrate inequality rests on ex post calculations. You can't do that. You can't do that. If discrimination occurred, it occurred when the agreement was signed. That's when it occurred. That's when it occurred. The moment it can't go beyond that. I mean, so I suppose it could have been earlier than that. It could have been earlier than the moment they signed the agreement, but it can't be any later than that. I mean, so what did you know then? You can't ex post. You can't look at things from what we know now. You have to look at things at the time. That's how we kind of do this thing. Catchphrases and rhetoric cannot substitute for sound legal standard duly supplied by evidence, which the plaintiffs do not provide. I agree. The women's team in their we critiqued the hell out of it earlier, and the women's with respect to the equal pay, the women's don't have any standard that they're proposing. Presumably because if they did, right, in any way that made the numbers work, then the Soccer Federation might be happy and say, okay, great, we'll give you that deal. Right? So the women can't be too specific because it would undermine their bargaining position, but it also undermines their legal argument now. So they want it both ways, right? It's like, we can't tell you what was wrong in the past because if we told you what's wrong in the past, you might fix it, and that would ruin our leverage. Okay, but it also hurts your claim in the past. Nor do plaintiffs identify any genuine issue of fact. There's really not. The experts simply use different methodologies based on the parties' different legal standards to draw similar conclusions. The district court rightly considered the parties' bargaining history when rejecting the methodology as legally unsound. Yeah. And the supposed discriminatory statements on which plaintiffs rely, all mischaracterized or taken out of context, cannot create a factual dispute over whether or not they were in fact paid. Right. So that would go to the Title VII aspect, not equal pay. Right. Which is why I'm slightly dubious on the Title VII. Right. They can say all the discriminatory things in the world, but it doesn't impact the equal pay analysis. right? In the Equal Pay analysis, you just look at the money received and paid. That's the Equal Pay Act. In Title VII, which is employment-based discrimination on the basis of sex, right, you can then look at those discriminatory statements because it shows potential discrimination on the basis of sex. Irrelevant to the irrelevant to the Equal Pay Act, relevant to Title VII. Why? Because that's the law Congress wrote. What do you want from me? The district court was also correct to conclude that Title VII pay discrimination fails for the same reason. The critical question was whether it received lower pay than the men's, and the court had already held that it did not. I'm not sure that's necessarily the critical question in the Title VII analysis. Under law of the circuit, there's no daylight between the two statutes in terms of plaintiff's ability to recover on that kind of claim. So maybe it will make more sense when they actually get to argument. Second, and in the alternative, this court can affirm because the differences in the performance bonuses are readily explained by factors other than sex, right? So under the Equal Pay Act, and for that matter, Title VII, right, sex only has to be a factor. It only has to be a reason that you discriminated. But it's like, no, but you have to actually prove it, right? You have to prove it. And so, yeah, what you do is you say, there's a three-part sequence in this. By law, right? The first side says, you discriminated me on the basis of sex. Here's why. You paid them this, you paid me this, right? That's the claim. The response is, well, okay, but here's why we did that. It wasn't because of sex, it was because of insert these other reasons. And then the third step is back to the person who started to prove that that isn't the case. Prove it's just a fig leaf, right? It isn't really those reasons. It really was sex the whole time. They're just making excuses. Yeah. At the time the CBA was entered, the men historically brought in greater revenue than the women. The women also specifically bargained for the compensation structure that prioritized security and benefits over high risk and high reward bonuses. Both are well-recognized job-related factors other than sex. This court should affirm. Yeah, whether or not you want salary or commission or some combination of both, yeah, that's pretty well recognized as a factor. The court may review a summary judgment de novo because it's on an issue of law. That's why it's de novo, right? Because the facts are not in dispute, so there's no issue of fact. So the only issue is law, and that's definitely true at the district court stage. So it's like, well, even under the best factual reading, they don't win as a matter of law. So it's de novo. What's the law? Congress passed the Equal Pay Act as an amendment to the Fair Labor Standards Act to eliminate the purest form of sex-based wage discrimination, paying women less because they are women. That's the key part. Because they are women. If they're paid less for other reasons, it's not because they're women. The Equal Pay Act provides for the following. No employer shall discriminate within any establishment in which such employees are employed between employees on the basis of sex by, paying wages less at a rate or blah, 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 whatever. But yeah, the plaintiff carries the burden to establish this prima facie case. They must prove that they were compensated at a rate less than the wages paid to employers at an opposite sex, which seems really, really hard since the women were in fact paid at a rate higher in terms of total amount of dollars of revenue. That would be, yeah. These other employees worked in the same establishment, which is debatable. And the employees performed equal work, which is also debatable. It's similar, but equal. The district court held the plaintiff's case failed at the threshold because they were not paid at a lower wage rate. In so holding, this court applied the legal standard by looking to how much the plaintiffs made in total compensation compared to the men, indisputably more, and by recognizing the two teams were not paid under the facially unequal collective bargaining agreement. On appeal, plaintiffs provide alternative standards that compare each unit of compensation in isolation or rest on some undefined measure of performance judged in hindsight, which is a no-no. These alternatives are ill-defined, unsupported by any persuasive authority, and would lead to perverse results. It is axiomatic that a female employee earns more than her male colleague performing the same work. The Equal Pay Act does not apply to her. If you earned more, You can't sue for Equal Pay Act violations. The other ones can, but not you. The EPA provides an employer from paying an employee at a rate less than the rate it pays his wages to employees of the opposite sex. So if you're paid more, not so much. And EEOC regulations provide that wages generally include all payments made to or on behalf of an employee as remuneration, whether called wages, salary, profit sharing, bonus, or some other name, including fringe benefits, like the child care and the pregnancy plan and all that stuff. The regulations likewise define wage rate to encompass all rates of wages, whether calculated on time, commission, price or piece, job incentive, profit sharing, bonus, or other basis. That is, all components of pay must be included in making the requirement wage rate comparison. Fair. Courts regularly engage in precisely this analysis. They compare female and male employees' total amount of compensation over a period of time to determine whether there's a prima facie case. The district court followed that well-settled approach here. Examining all components of the two teams' packages, the court held the women's team was paid more than the men's team on the aggregate and per-game basis. This conclusion was based on facts that were undisputed and remain undisputed. Starting with aggregate figures from 2005 to 2019, the Soccer Federation paid the women's team more than the men's, nearly twice as much in total during that time period. This is true even excluding payments the Soccer Federation made to subsidize the women's soccer league thing. So then we see the two numbers. The men's team was paid $19 million throughout those years. The women were paid $35 million per year. So, fun times. And the district court did not rest this overall comparison. The women's team had argued the aggregate remuneration was not the proper measure because they worked in far more games, were paid less on a per game basis, which no. So the women's team presented evidence that the women's players were paid more than their male counterparts on a per game basis too. Yeah, the women's received an average of $220,000 per game compared to $212,000 per game. And these averages understate the difference because they exclude payments the Soccer Federation made to each player's association, some of which the women received and the men did not, the women's soccer league salaries, which are not part of this calculation, and one of the women's victory tours. So that's not all the money they made. There's more money beyond that too. As a further metric, the Soccer Federation presented unrebutted evidence. The women's team earned more per dollar of revenue the team generated. The women's team received 27% of the revenue generated from their events, which is prize money, ticket sales, and other associated payments. The men's team received only 24. 27, 24. Yeah. That remains true if they bundled the revenues allocated to both teams. Similarly put, there's nothing surprising about the district court's holding. The women's team players were indisputably paid more than the men across several measures, and they don't have a claim for being paid less. A total compensation works well for the vast majority of EPA claims, but as both the Soccer Federation and District Court acknowledge below, there are circumstances in which an employee should be able to establish prima facie case even if total compensation ends up being higher. The prototypical example is where individual wage components are facially unequal. For example, commission rates, and are not offset by other wage components, base salary. So this goes back to that commission example with the women realtors who were paid at like half the rate as men, but they actually wound up getting more money than the men because they were just really good. And then in that case, the court said, yeah, not so much with that, because they're paid at half the rate. Right? So they wound up with more money, but they're paid at half the rate. But what they're pointing out here is, unlike that, here there's compensation for it elsewhere, right? So everything was equal but for that one thing. So there was no compensation. Here, there's compensation because the women are getting paid somewhere else that the men aren't getting paid. So it's a trade-off, as one might do in a negotiation, for example. The Sixth Circuit's decision in Benice illustrates. There, a health spa required its employees to sell spa memberships to only customers of the same sex. The employer paid the women 5% and the men 7.5%. We see problems immediately. The employer argued that the female employees could not establish a prima facie case because they ended up being about the same in the end, which means the women worked harder. The Sixth Circuit disagreed, and rightly so. It reasoned that paying the women a facially lower rate effectively locked up the female employees and only female employees into an inferior position regardless of effort or productivity. The rule derived from this and similar cases is an important but limited one. Total compensation cannot make up for a facially unequal pay structure. But as cases distinguishing have made clear, a pay structure is not facially unequal if other components of the wages can offset. This is how courts, including the Sixth Circuit, have understood this exception. And it makes sense. There's nothing inherently unequal about one agreement that pays women $100,000 plus 4%, and another that pays men $50,000 plus 8%. So you tell me, which is the better deal? On its surface, remember, because you don't know what's going to happen in the future. So which is the better deal? $100,000 plus 4% or $50,000 plus 8%? I mean, it's not obvious. The bargaining agreement here are not facially unequal. There's no individual wage component that differs between the women's and men's team, while all else remains the same. Instead, as the district court recognized, the two teams have fundamentally different structures. As a result of their considered choices during bargaining, the women's bargaining agreement included many forms of compensation. The men's does not, including here's what the women got in exchange for the not bonuses. Remember, has to be compensated. Here's what they got: annual salaries, severance, pregnancy, parental leave, child care assistance, medical, dental, sponsorship of 401k, an annual licensing fee, partnership bonuses tied to ratings, sponsorship, and ticket sales, and additional salaries to supplement the women's soccer league. Well, I don't know about you, but that sounds like a lot of stuff that the men weren't getting. That sounds like a lot of things. They sound like good things, incidentally. If you want those things, great. If you don't want those things, also great. Who am I to tell you what you want? Especially if I don't know you. If I know you, maybe, but not as much. Many of these components are guaranteed even if the women's team does not play, whether it's due to coaching, injury, or personal reasons. In fact, the women's players can count on being paid even if their matches are canceled entirely. A bargaining choice that proved prescient when all matches were canceled for nearly a year during COVID-19. The men's players, who were paid F all, did not benefit from that protection. Right? The Soccer Federation can't say, geez, we had a bad year, we can't pay you. The Soccer Federation can't do that. They have to pay them anyway. It's like, here's your money. And to the men, they said, what about our money? He said, well, I think, there might be some throwing away food in the garbage can or something if you want to go rummage around. But, in short, this case is worlds away from that case dealing with the fitness club thing. The CBAs are not nearly identical, with one discrete feature that's unequivocally worse. Following robust negotiations in which the Federation took its cues from the players themselves who wanted these things, the Soccer Federation compensated each team under bespoke pay structures tailored to their unique preferences. And under these agreements, the women's players came out ahead. In these circumstances, the district court correctly held that is, as in most situations, the fact that the women's team made more in total compensation than men defeated the argument. Yeah. Plaintiffs critiqued the district court's reliance on total compensation, but they failed to persuasively answer this key question. If total compensation is not the right measure, then what is? Yeah, it's helpful. It's helpful if you're complaining about something to have at least a suggestion as to what would fix the problem. Otherwise, why are you complaining to me about it? What do you expect me to do? I mean, unless you just want an ear. So if you're complaining about it just because you want an ear, then that's fine. I understand that. But if you're complaining to me for the purpose of solving the problem, if you don't have any ideas, I don't, maybe think of something. Plaintiffs critique the district court's reliance. They allude to 4 possibilities. A hypothetical post hoc, which just no, total compensation analysis that instead measures what the women's team would have made under the men's deal. An approach that requires each discrete compensation term to be exactly the same, which would incidentally mean the women's team wouldn't be able to have any of its benefits. Some undefined performance-based model where the rate of pay will be deemed unequal whenever a team that wins more is not paid substantially more. And an approach evaluating whether the expressed terms of the CBAs are unequal based on ex post figures. No. Each of these alternatives fails because it finds no support in law. The primary theory plaintiffs advance below, and the only one they support with expert testimony, is they are paid a lower wage rate than the men because they would have earned more under the men's deal. Yet this doctrinal foundation for this theory is found nowhere in the appeal. Right? So our theory is it's illegal because because they would have earned more. But they don't actually provide a foundation for it. They merely summarize the experts' evidence supporting the theory in 3 paragraphs of the final 10 pages of their brief. That plaintiff barely defends to defend the cornerstone of their case is telling. Neither law nor logic allows plaintiffs to say that she was paid a lower wage rate by showing she would have been made more under a different contingent pay structure she rejected. As the district court put it, plaintiffs cannot now retroactively deem their CBA worse than the men's deal by reference to what they would have made had they been paid under the men's pay-to-play structure, when they themselves rejected the structure. They didn't want it. By offering a methodology that evaluates the value of each agreement only in hindsight, knowing how well the team actually performed, plaintiffs ignore the ex-ante, that is, the before, context in which these compensation packages were negotiated. In their view, the parties' painstaking, multi-year negotiations were all a charade, because federal discrimination law guarantees the women's players all the men's upside with none of the downside. So yeah, like, why were we negotiating this entire time over several years? Why were we negotiating again? Apparently it was all a charade the entire time, because none of that mattered. This is strange. Reinforcing the core problem, the Soccer Federation offered unrebutted evidence that the men's players would have been paid more money under the terms of the women's deal. I just want to say that again because it's such a... Reinforcing the core problem with this approach, the Soccer Federation offered unrebutted evidence that men's players would have gotten more money under the terms of the women's deal. So under plaintiff's theory, the Soccer Federation was discriminating against players on both teams based on his or her sex at the same time. Well, this is a neat trick, right? The women would have got paid more under the men's deal, but the men would have got paid more under the women's deal. So that means we were discriminating against both the men and the women's team, both on the basis of sex at the exact same time. We were sexually discriminating against the men and the women. The district court found this untenable. And the court has likewise rejected the notion that an employer can prima facie discriminate against a male employee on the basis of sex. At the same time, it discriminates against a female employee on the basis of sex. That's pretty hard. That's pretty hard. It's a little hard to discriminate against a man and discriminate against a woman in the same way, and that discrimination be on the basis of sex. This is sexist. Well, whatever else it isn't sexist because same discrimination. See, if it's the same, you can't discriminate because it's the same. You can't separate them because they're the same. Yeah. Plaintiffs point to no case in which a court allowed an Equal Pay Act plaintiff to prove the prima facie case this way. Instead, they argue the district court was wrong to even consider the trade-offs because the Equal Pay Act contains no exemption for pay discrimination in the collective bargaining agreements. Again, apparently all that CBA negotiation was one massive farce. But plaintiffs' authority on the point are readily distinguishable. In Corning Glass, the Supreme Court held that, on the facts of that case, a newly collected new bargaining agreement provided for equal base wages, prospectively, but continued to provide for unequal base wages for employees that were already hired, could not cure the violation. So in this case, Corning Glass, they got a deal, equal pay for new employees, but not for the old employees. That doesn't solve the problem. Under Anderson, presents similar facts, and the court's dicta on the subject reflects the same principle. And Dean involved a husband and wife co-team forced to sign a facially discriminatory agreement. Plaintiffs also point to EEOC regulations stating that the inclusion in a collective bargaining agreement of unequal rates of pay does not constitute a defense. But that reflects the holding in Corning. If the EEOC is now contending that regulation forecloses an employer from ever relying on a CBA or other negotiated agreement, that position is contrary to the guidance in the own manual and not entitled to Chevron deference in any event. Well, we all know how far Chevron deference goes, so we'll say we're dubious on that one with unfortunate effect. Of course, an employee cannot escape EPA or Title VII liability simply because an employee agreed to it. That's not going to fly. Nor can an employee prospectively waive their rights under federal law. Can't do that. But that's not all what the Soccer Federation argued, or what the district court held. The court simply refused to adopt a flawed legal standard that ignored the negotiation history, the women's preferences, which are the thing that's driving all this, and the different pay structures to which the parties wanted. They wanted them. Indeed, the negotiations would have been a complete affirmative defense if the district court had reached that point of the analysis. Labor agreements that are factors other than sex can explain disparate wages. It was eminently proper for the district court to recognize negotiations reinforced why plaintiff's prima facie case was legally unsound. It was also necessary. A ruling adopting plaintiff's position would countermand federal labor relations policy. The Soccer Federation has an obligation to engage in give and take of good faith bargaining that is required by federal labor law. It sure is. It sure is. They must engage in good faith bargaining while honoring those players' choice to bargain separately. They sure do. Right. They have to. By law. Right. Federal labor law also prohibits the Soccer Federation from making unilateral midterm modifications to the agreements. To harmonize these equally important imperatives, when the collective bargaining agreement is neither discriminatory on its face nor in application, courts should not interfere in the process or tamper with the result. You know, that's a neat trick. You know, under the Equal Pay Act, okay, so under the Fair Labor Act, we're required to negotiate with your separate unions in good faith. But according to the plaintiffs, somehow, under the Equal Pay Act, we're forbidden from negotiating in good faith because it might lead to unequal results. So, yeah. As one might expect, it is disfavored if you run into a situation where your legal theory would require you to obey one law, where it's disfavored if doing something is required by one law and forbidden by another law. You know, under the women's theory, it would be required by one law and disallowed by another law. That's probably not the right theory then. The courts do strive, where possible, to give full faith and effect to all of Congress's pronouncements. So, you know, if your theory is they have to disobey the law, the courts are not inclined to go that way if they can avoid it. Perhaps recognizing the flaw in the experts where we would have made an approach, plaintiffs advance a different theory on appeal. Plaintiffs now argue that merely have to identify any component of the compensation package that is less than the corresponding component. That's a dumb argument. Pointing to CBA's differences, bonus amounts for matches and tournaments, the plaintiffs argue that rate of pay for each component in the multi-category component must be equal. And they maintain that employers should be liable even if higher pay in one category can offset lower pay in another category. That's remarkable for several reasons. For one thing, plaintiffs took the exact opposite approach below. They told the district court it's undisputed, as set forth in regulations, that all compensation, including bonuses and benefits, should be considered. The Equal Pay Act definitely says that. It's not particularly ambiguous. The Equal Pay Act says consider all the things in any form, no matter what you call them. You call them salary, you call them commission, you call them, piece, which is like for every one you do, we pay you so much for every one, or whatever else you call it. No matter what, the label we don't really care about. We have to look at all the things. The EPA seems to be pretty clear on this. So the women said that because that's what the EPA says. It's right there in the statute. They further explain the EPA requires plaintiffs to account for other forms of wages. Correct. And alleged not only one form of overall wages was lower. Correct. The district court considered this point undisputed, which it is because it's in the statute. Plaintiffs cannot obtain reversal based on an argument they told the district court not to consider. Also an agreement that's flatly contradicted by the statute. That's a problem. Plaintiffs were right then and they're wrong now. They rely on dictionaries defining rate as an amount of something measured per unit of something else. Wow. Okay, so here's what the plaintiffs done in their own wonderful little universe over here. Here's what the plaintiffs have done. They said, I want to define the word rate. Okay, great. That's helpful. They said, let me turn to a dictionary. Now, dictionaries can be helpful and a good source of information for understanding what words mean, including in legal text. So dictionaries are fine. And they said, hey, rate means amount of something measured against something else. Now, that all would be fine, but the statute provides its own definition. Remember? The statute says rate of pay, which includes all pay in all forms, no matter what label you give on it. So as you might expect, which do you think has better legal authority? What Merriam-Webster's dictionary says or what the congressional statute says? Which definition should we follow? It's such a mystery. True, that means that the statute directs a comparison of each wage against a common denominator. The relevant question is what comprises that rate? As the EEO explains, all payments made to the employee, which is what the statute says. And EEOC guidance the plaintiff invokes is not to the contrary, which would be pretty hard because it's what the statute says. The same is true of the case law. Nearly all the plaintiff's cases fit into this Benesse fact pattern. In Ebert, the court rejected total remuneration when the female police communication officers made more than male fire communications officers only because the women worked overtime and holidays. Right. That means the rate wasn't the same. They made more, but they worked harder. So yeah. In Keller Brothers, some women made more in total compensation because they sold more houses. The minimum salaries were the same, but the men received a higher commission because they had families to support. Apparently someone actually said that. Right? That's in a record somewhere. The reason we're giving the men more is because they have families to support. First of all, how do you know the women don't have families to support? Second, the Equal Pay Act. You can't do that. And in Health Management Group, the plaintiff earned more because she sold more franchises, but her base salary and commission rate were lower. So I earned more, but, it was hard. Again, the district court agreed that Congress could not have intended the absurd result that they could pay a woman $10 an hour and a man $20 an hour, so long as the women negated the obvious disparity by working twice as many hours. That would be pretty stupid. But that just reinstates the exception. It does not support far broader proposition that each component must be measured in isolation, which is directly contrary to law. And courts faced with pay structures similar to those ones here where one component might offset another, have refused to find prima facie merely because the terms are different. It's easy to understand why plaintiffs' new legal theory would itself lead to absurd results Congress could not have intended. If it's commonplace for employers to offer employees to request different combinations of pay components, as was the case here, one employee may place greater value on a guaranteed salary and the certainty and security that comes with it, while another might want their compensation to come in the form of bonuses contingent on pay, performance, or other rewards tied to success of the company. But under plaintiff's new theory, such differences are necessarily unequal. If the employer in plaintiff's shoe, salesperson example, was already paying a male salesperson on commission, the employer would have to reject a newly hired female salesperson request to receive hourly wage instead, even if the hourly wage could far exceed what the man is making. So I can't do it because I'm already paying the man on commission, so that's dumb. This is dumb. Plaintiffs never confront the consequences of their rule, which again makes women look bad everywhere. Because it's like, can you not think ahead? First of all, how do you not understand basic economics of we can't give you money that doesn't exist because unfortunately the world is unequal. The world is unequal. Women's soccer is not as popular and there's just not the money. So how do you miss that? And second of all, it's like, how do you not consider like what happens next? Like if you're right, what else must necessarily flow from that? All right. Well, I guess your power to negotiate must wither and die. Because you can't negotiate because you might negotiate for something different. I guess there can't be a women's and men's union. You guys have to merge. This is directly contrary to federal labor law, by the way, but that would have to be the logical conclusion of their argument. So yeah, that means we'd have to directly go against what a statute says, which, seems like the wrong legal interpretation. And if any difference amounts to prima facie violations, Soccer Federation will have no choice but to require teams to agree to identical terms, even if it's not what they want. Right. I mean, there's no alternative. It would not serve the cause of gender equality in the workforce to take away employees' ability to use their leverage to obtain conditions that they feel fit for them. Players also emphasize their performance and argue because the women's team won more than men, they should have been paid even more. Or put another way, players maintain they should not have to outperform the men to make the same amount. That soundbite undoubtedly has some intuitive appeal, but as a ground for reversal, it falls apart. Plaintiffs accuse the district court of failing to account for performance as a measure of work. They are entirely unclear, however, how the district court was supposed to assess performance in the context of this case. How am I to measure that exactly? Perhaps the answer is one or both of the theories addressed above. Dr. Cook's methodology, and giving the plaintiffs the benefit of whatever deal paid more, or plaintiffs' new look at each compensation in isolation approach. But those legal standards are fatally flawed for the reasons discussed, and beyond that, plaintiff offers nothing. Plaintiff also fails to identify evidence in summary judgment record that provides a comparison based on this amorphous performance theory. They do not, for instance, point to any evidence that calculates the women's players' total wages during the relevant time period, divides it by some measure of performance, and uses the common denominator to compare it to men's pay. Plaintiffs had that burden, and simply saying performance should matter in some abstract sense doesn't do it. Yeah, you can't say, like, performance should matter. Okay, what do you want me to do? What do you want me to do? Measure performance. How? Where? Just measure it. I as a court, I don't know how to do that. I don't know how to measure performance. Unless someone can give me some help here. That'd be great. Plan's performance-based argument also ignores the ex ante, which is the at the start context in which the contracts were negotiated. How could Soccer Federation ensure an equal wage ex ante based on what their performance ex post? So that's a great question. How could we have ensured a equal wage at the beginning based on what happened at the end. See, the thing is, time works in one direction. So I'm not sure how we could have factored what happened at the end into what happened at the beginning. So, time has this one directional linear thing kind of going on. Short of requiring the teams to agree to identical CBAs, plaintiffs do not say. In arguing the play should track their win-loss record, plaintiffs also elide the actual terms of the compensation packages they negotiated. While the men's team chose a pay structure that was based exclusively on performance, as the contract defined it, the plaintiffs deliberately did not. As a result, women's players are not just paid to win. That's the men's deal. The men are paid to win. Are you confusing your deal with the men's deal? They're not even paid to play. The contracted players are paid guaranteed salary and benefits regardless of whether they ever set foot on the field. Holding the women's team's players to the terms of the bargaining they collectively seek before they knew just how successful their teams would be or whether each individual player will continue to pay is hardly penalizing the women's team for their success. I mean, yeah. Finally, plaintiffs' understand of employee performance is too narrow. To run on with their example, an employer may not view a salesperson who sells 100 pairs of shoes with a $10 profit margin as outperforming another salesperson who sells $50 of shoes with a $100 profit margin. Yeah, so you can't, that doesn't make any sense. If you sell 10 shoes at $10 and 50 shoes at $100, those are not the same amounts of money. Likewise, even in the sports world, performance is not all about the win-loss record. Bonuses are not tied to wins in the abstract. They're tied to revenue that comes with it. When performance is viewed holistically, the women's team came out ahead. They are paid more than men. And the guarantee that women would never receive less dollar per revenue was fulfilled. Plaintiffs also argue they established a prima facie case because the express terms of the team's collective bargaining agreements showed the women's and men's pay were unequal. But plaintiffs attempt to compare the two teams' packages across the bargaining agreement's distinct components. It is brand new, full of methodological defects, and not from the beginning at all. What the district court should have done, the plaintiffs argue, is divide the various features of the team's compensation into two buckets. Okay, bonuses and appearance fees. All agree the potential bonuses were generally lower for the women than the men. Plaintiffs now also claim, however, that the women's players were also paid lower appearance fees too. What exactly are these appearance fees? Plaintiffs describe them as the amount players receive for playing in games, regardless of outcome. But contracted players are not paid on that basis. They're paid for just being a member. You're not paid for playing. Literally, you're not paid for playing. You're just paid. That's the deal. No matter, the plaintiffs say, the district court should have just added up the players' guaranteed salaries during the 7-year period, add up the amounts the benefits paid those benefits, and divide by the total amount of games. Creative. Plaintiffs feel compelled to explain how they arrived at this contracted player appearance fee figures because the numbers are not in a summary judgment record. Neither is their table 2. So this is great. This is great, and if the Court of Appeals catches them doing this, they might get whacked around a little. You know what they're trying to do? And I didn't notice because I don't know the record like that well. I mean, how would I notice? I don't know the record that well. But do you know what they just did? They tried to bring in new facts. They tried to bring new facts into the appeal. Like, for example, this table 2, which is not in the record. All right, just as a reminder of Law 101, the district court determines what the facts are. And the Court of Appeals does law. If the Court of Appeals catches you trying to bring new facts in, they may be grumpy. That's a big no-no. That's a big no-no. Plans suggest the district court should have taken the initiative to do these calculations on its own. Oh, okay. Okay, you want the district court to do your homework for you. You want the district court to do math now. The district court doesn't do math. The district court does law. But those figures do not and could not appear on the face of the agreement. These per average game appearance fees are based on variables unknown at the time they're signed, including the number of games the women's ended up playing and what the Soccer Federation ended up paying in severance, parental leave, and the like. So you can't determine it at the beginning because you literally don't know what it is. Even if this court were to consider plaintiffs' new math in the first instance, no, it's severely flawed. Plaintiffs' average appearance fee for contracted women's players assume that each player appeared in every game during the 5-year period, which no. That was not true for even a single player. Yeah, you wouldn't expect it. And when those numbers are properly adjusted by the number of times a player actually appeared on the roster, several players earned a higher game per game appearance fee than the men's did. So when you calculate how many games you guys actually played, the women got paid more than the men again. Plaintiffs' figures also leave out a lot. For example, they ignore the Soccer Federation's payment to the women's team, even though those amounts qualify as wages under the law. It sure does, and the women's team controlled how much the amounts were dispersed. Plaintiffs do not include the amount Soccer Federation paid to subsidize the women's players' participation in the soccer league, which would have to qualify as compensation, even though the Soccer Federation would have been obligated to continue making a substantial percentage of those payments as part of the salaries if the league failed, and also like 50% more. Nor does plaintiffs' appearance fee comparison account for the fact the contracted players do not have to appear at all. The value of a guaranteed salary, entirely lacking on the men's side, is zero. The contracted appearance players are not necessarily required to appear. The men's guaranteed salary, guaranteed compensation, in all of its forms, the men's guaranteed compensation is a big fat zero. So, in the end, the Equal Pay Act calls for two agreements to be compared based on their express terms. Then the agreement should be actually compared on a at the beginning basis, not based on information unknown. True that. All wages should be included. That's the law. And guaranteed payments should not be treated the same as contingent. But plaintiffs never even engaged in that analysis, not in the district court, not on appeal. They did not meet their burden because it's impossible. The women don't have an Equal Pay Act case. It's impossible. The law does not support them. Watch the Ninth Circuit disagree with me and watch me lose my mind. Plaintiffs argue the district court independently erred in resolving the genuine disputes of material fact against them in summary judgment. But plaintiffs and their amici make the mistake of disputes regarding legal standards for factual disputes. They cannot get to a jury based on facts of expert evidence that do not bear upon proper legal analysis. And once the district court's legal standards are accepted, plaintiffs do not identify a single instance where the court resolved a material fact against them because they're legitimately disputed. Yeah, this is fun. The women's team is trying to argue, it was improper for summary judgment because we still have material disputes. But those material disputes are over a law, which is not what a jury does. Juries do facts. So does the appeal court, by the way. So, that's not a material dispute. You agree, but it's not material. It's not factual. No. Plaintiffs argue the district court dismissed the express terms of the CBA based on the mistaken belief the agreements could not be compared. But the court never held the agreements could not be compared. It held the plaintiffs had not introduced any evidence comparing or otherwise valuing the agreements in any legally sound way. That's the precise job of a district court at summary judgment. What are we talking about in chat now? Melanie? Oh, I remember. Yeah. Okay. Never mind. Carry on. Second, plaintiffs argue that competing expert evidence created a question for the jury. But this case does not involve the typical battle of experts. Right. The plaintiffs clearly disagreed about whether the women were paid at a lower rate than the men. But their divergent analysis on that point reflected the parties' disagreement about the proper legal framework, right? So it wasn't that the experts disagreed under a common set of facts. Apologize. It wasn't that the experts disagreed on the facts under a common legal principle. They disagreed about the underlying legal principle. So that's why their facts were different. They weren't talking about the same thing. The district court agreed with the legal theory advanced by the Soccer Federation and its expert told compensation because that's what the law is, and rejected the legal theory advanced by plaintiffs and their expert to evaluate what they would have made under the collective bargain, the men's agreement. Again, that's a legal question for a court, not a facts question for the jury. True that. Third, plaintiffs say the district court improperly dismissed statements made by Soccer Federation representatives. The court similarly did not find plaintiffs' evidence on that front compelling, which is a fair factual determination for the court. And maybe where this is going in Title VII, right? So how much that analysis, how much it matters is like a weighing of facts, right? So maybe he didn't consider them particularly persuasive, which is a factual question. Or maybe he didn't believe them or whatever, right? So maybe that's the answer. But the court ultimately rejected that evidence because it was legally irrelevant. Any purported statements from the women's players that they were paid less could not make it true. Yeah, it doesn't really matter if the Soccer Federation said that women were paid less, or the men's team said the women were paid less, or, doesn't matter if the men's team played less. I don't know where you got this gotcha of someone saying they were paid less, but while that is admissible evidence, the hard numbers seem to disagree. So, yeah. Plaintiffs find no case where a court has found prima facie showing on unequal pay based on an employer statement alone. Yeah. In any event, no reasonable juror could find the statements amount to admissions of pay inequality in the first place, Plaintiffs first exert a statement from the then vice president that was made part of the December 17th campaign letter discussing player development at all levels and the need to grow the game. That sounds good. The letter made no reference to the compensation of the senior women's team. Plaintiffs also cite a different statement in which, in response to a journalist's question about ensuring equal pay, nobody defined what they meant by equal pay, and there's no indication that he said anything other than what the Soccer Federation believes. The Federation is committed to pay equality, which includes considering each team's expressed preferences. Next, plaintiffs mischaracterized a former president's deposition. That person said only that he would not have authority the same World Cup bonuses because of the massive gap in the prize money. Yeah, he can't authorize the same bonuses because there's no money. Plaintiffs suggest that this person provided negative testimony about the absolute quality of the women's team. That's wrong too. While he initially suggested there might be a difference in the quality of competition in women's soccer, not the quality of the women's team, he clarified that FIFA and the NCAA and virtually every other organization have separated teams based on genetics, biology, and so on. Maybe that's less true now with the genetics and biology because we don't really believe in that anymore, but that's a different discussion for a different day. Yeah, when will someone from the men's team sign up for the women's team? That's a real question, right? They dominate, right? Plaintiffs also invoke a comment from outside counsel during the CBA negotiations, a statement they unequivocally deny making. The disputed comment at most reflects the fact the women had generated less revenue than the men as a historical matter, and the women would be unlikely to bridge that gap given the money prize devises. As discussed below, the revenue an employee generates for employee is undeniably a legitimate factor. Yeah, it sounds like all these guys are just based. They're just, like reality. There's a thing called reality, and there's just not the money. I don't know what you want. Give us more money. From where? All right, so now we're going to get into Title VII, which is the part of the analysis I was waiting for personally, right? Although I do love, on a personal level, just continuing to browbeat them on the equal pay because it's really dumb. So I enjoyed that, but this is where I'm more interested because I'm interested in the legal analysis to see if the men's team can persuade me to change my mind as to the Title VII stuff. So let's see. Title VII prohibits employers from discriminating against any employee with respect to compensation, terms, conditions, or privileges of employment because of sex. Like the Equal Pay Act, Title VII prohibits paying an employee less because of sex. Unlike the EPA, Title VII requires proof of discriminatory intent. Well, it's not equal pay, right? Because Title VII prohibits paying an employee less, but also prohibits, which is compensation, but also prohibits terms, conditions, or privileges of employment based on sex. So it's not just pay, unlike the Equal Pay Act, which is just pay. So different wording, different analysis. Plaintiff's theory of Title VII pay discrimination was the soccer federation paid them less than male players, that there was disparity of wages between the two teams. This court has squarely held that when Title VII claimant contends they've been denied equal pay for substantially equal work, the Title Equal Pay Act standards apply. Those standards require the plaintiff to bear the initial burden of showing, among other things, the pay of the women and men were unequal. So the district court correctly concluded the absence of evidence of unequal pay likewise foreclosed Title VII. Plaintiffs' arguments to the contrary lack merit. They argue that Title VII is broader than the EPA. Well, it is because it includes more things. It's necessarily broader. But the Supreme Court case they cite, County of Washington, merely holds that Title VII wage discrimination claims may proceed even if the plaintiff is unable to point to a male comparator performing equal work. Where Title VII wage discrimination is not based on equal work theory, it must be analyzed separately under Title VII standards. Because plaintiff's EPA claim did not fail because they were unable to show that the men's team performed equal work, Soccer Federation does not contest that element. Well, I kind of do, but that's me. Their claim failed because they could not establish the pay of men and women was unequal. Plaintiffs saw no case in which the EPA failed because the plaintiffs were paid equally to or better than the men performing work, and yet Title VII's claim based on pay disparity was allowed to proceed. Here, too, plaintiffs emphasize the direct evidence of discrimination. But even if soccer federations betray a discriminatory intent, which they do not, they still need to suffer they suffered an adverse action. Okay. This analysis is thin. Right? It's only 2.5 pages. The entire Title VII analysis is only 2.5 pages. As opposed to the EPA, which was like 47 pages. Right? So the EPA analysis was 47 pages. The Title VII analysis is 3 pages long. And I'm not sold. So, I mean, usually, why do you think they spend so much time on EPA? Because they have it in the bag, right? They have it 6 ways from Sunday, right? So they argued all 6 ways like good lawyers. Why do you think they only wrote 3 pages? Because they don't really have it, right? So, I'm disappointed for myself at this point because I personally was really looking forward. This is what I was really looking forward to from a legal education standpoint. I was looking forward to the Title VII analysis because I thought the women made a decent case. I was like, yeah, this might be tenable. I was really looking forward to it. Like, man, maybe the women misstated the law. Maybe they misquoted it. Maybe they've, mischaracterized it. I'm really looking forward to this. And what I got was 3 pages. My day is ruined and my disappointment is immense. Plaintiffs have focused on bonus amounts, meaning the amount promised to individual games and tournaments, as a critical pay differential they believe is actionable. The dollar amounts of the potential bonuses in the CBA are generally higher for the men than the women, but it's not because the women players are women. It's because the men's players have the potential to earn more revenue from the competition, and the women's team bargained for a pay structure that prioritizes guarantees to payment. Both are factors other than sex. This affirmative defense was thoroughly briefed below and has been addressed by plaintiffs and their amici on appeal. It provides an alternative ground to affirm, right? So you could agree for the reasons the district court said, or you could agree for this reason, which is slightly better in my view, in terms of the analysis. Slightly better is from a practical standpoint, is this argument. So I'd be tempted to affirm on these grounds if I were in that position. Plaintiffs have focused on bonus amounts. Oh, we read that. It is a fundamental premise of labor economics that compensation should be tied to incremental revenue a worker's performance generates for their employer. Accordingly, if an employer derives great benefits from one employee as compared to another, that's a legitimate benefit or legitimate reason to discriminate. That's the case here. The higher bonuses in the men's team were based on the team's potential to generate more revenue for the federation. The bonuses fall into 3 categories: friendlies, World Cup, and non-World Cup. Dr. Cook's own calculations show the higher bonus amounts for friendlies in the men's teams are fully offset by the generated salaries and other payments in the women's team, which just leaves the bonus amounts for the World Cup and other tournaments. For both, there's contemporaneous and obvious revenue justification for the difference. Over 90% of back pay damages Dr. Cook calculated for the 5-year period are attributable to the World Cup bonuses alone. The differences between these bonus amounts is fully explained by the massive gap in prize money: $400 million for men, $30 million for women. To put in stark terms, Soccer Federation received $9 million from FIFA when the men advanced to round 16, but only $2 million when the women won. Yeah. That prize gap money is something Soccer Federation has been fighting narrow for years. But the Soccer Federation doesn't control FIFA. That's definitely true. And contrary to the arguments of plaintiffs' amici, the differential cannot be chalked up to rank sexism on FIFA's part, because FIFA also is working by economics. Over 2 billion more people watch the Men's Cup than the Women's Cup. Because FIFA holds sole broadcasting and ticket rights for that tournament, that translates into more revenue that they can distribute. And when you compare the two teams' potential bonus amounts as set forth in the CBA as a percentage of FIFA money, the women's team comes out on top once again. Soccer Federation paid the women's team all FIFA's money plus more, something the U.S. Soccer Federation not planned to do for the men. Plaintiffs nonetheless argue the Soccer Federation was obligated to compensate the women's team as if they had won the Men's World Cup. But surely federal law does not require the Soccer Federation to pay out $50 million in phantom revenue it's never received. And then the president of the Soccer Federation explained, making up that gap would break the Soccer Federation, by several orders of magnitude, it sounds like, which must fulfill its mission to fund other national teams and programs and make a long-term investment in sport in all levels. So while the Soccer Federation could and did promise to increase women's bonuses if FIFA increased the prize money, it could not contractually promise to pay them millions of dollars it wouldn't collect. The money just isn't there. Why is this so hard for the women's team? The money isn't there. The men got $9 million for making it to the Sweet 16. The women got $2 million for winning the World Cup. Where is this money coming from? I mean, if the men's team had one, they got paid $50 million, but we don't have it. Plaintiffs' counterpoints are not persuasive. They first note the parties set forth the bonus amounts before knowing exactly how much FIFA would award. But the U.S. Soccer Federation had no reason to think FIFA was going to drastically depart from past practice. Plaintiffs do not claim otherwise. Plaintiffs next suggest the Soccer Federation could have agreed to pay the women's team some of the men's prize money. I suppose that's possible. But the men have never won a World Cup, so the Soccer Federation would have been committing to redistributing revenue it might not receive. At the time the Soccer Federation entered into the agreement with the women, it already promised to pay the men's bonuses amounting to a substantial percentage of any FIFA reward earned. The men's team has never relieved Soccer Federation of their obligation. The men want to be paid for what they agreed to. Plaintiffs finally argue the differences in bonus for the World Cup qualifying matches cannot be explained because FIFA does not pay prize money for those. But U.S. Soccer Federation can generate revenue from certain World Cup qualifiers for the men's team because it owns those broadcasting rights. It does not own the rights to other tournaments that double as women's qualifiers. And the revenue stakes of merely qualifying are exponentially higher for the men's team than the women's. Although far less significant in terms of dollar amounts, the same dynamic explains the men's higher non-World Cup tournaments too. The higher bonuses track millions of dollars in prize money these tournaments could conceivably generate. The average prize money payout for winning one of these tournaments is $3.9 million, which corresponds to a $2.6 million bonus. By contrast, none of the women's non-World Cup teams pay any money. Any money. None. There's no money. Yet the Soccer Federation still promised the women an average bonus of $858,000 for winning. So once again, the women received a higher percentage commission. Yeah, a much higher percentage commission. In that particular case, infinite. It's infinite. The amount of revenue is zero. The amount of pay is bigger than zero. The percentage is infinite. Infinite percent. It's hard to do much better than infinite. Plaintiffs are also justifiably proud of the fact they generate more revenue in prize money and ticket sales for the Soccer Federation. That's a testament to the women's success and the growing popularity of women's soccer. But when the parties negotiated the agreement, which, is when we have to look at things, they did not know the women would generate more revenue. How could they? And historical figures suggest that they not, which, yeah. In the 4-year cycle preceding the collective bargaining agreement, the men's team brought in $64 million for soccer, compared to $15 million for the women. So, just to state that again, for the previous 4 years before the collective bargaining agreement, the men brought in $64 million. In that same 4-year period, the women brought in $15 million. One might note that $15 million is less than a quarter of $64 million. And although these other revenue streams were not broken by a team, both sides estimated from television ratings the men were most likely responsible for a greater proportion of television ratings. The two teams' track record of revenue generation further demonstrates that bonus differentials were not in fact based on sex, but, economic reality. The bonus amounts in the women's collective bargaining agreement are lower than the men's because the women prioritize guaranteed salaries and other benefits over higher bonuses. When an employee negotiates and procures a unique payment structure, that is a factor other than sex. Or if it is because of sex, it's because you wanted it on the basis of sex. So it's you wanted it. You're discriminating against yourself on the basis of sex. Yeah, that's great. Why are you hitting yourself? Women's players, why are you discriminating against yourself on the basis of sex? Why are you hitting yourself? The plaintiffs concede the Soccer Federation offered to pay them the same pay-to-play structure as the men, but note they were never offered the same bonuses because it's impossible. The differences in prize money and revenue go a long way to explaining that, yeah, not to mention the fact that was the Soccer Federation's opening offer. But the women's team also never asked for the men's agreement, but we offered it anyway. In both negotiations, the women's starting offer included the guaranteed pay. They wanted it right from the very beginning. And after the Soccer Federation said, how about not so much with the guarantees, the plaintiffs said, no, we want the guarantees. Plans expressly reiterated they wanted the men's bonus amounts, but did not want every other aspect. These women are making women everywhere look bad. The women explicitly said, because these are quote marks, right? They explicitly said they want the bonus amounts, but they don't want every other aspect of the men's deal. No. Okay, let me explain how negotiation works, which I can't believe I have to explain how negotiation works, given that you were in a multi-year negotiation process and probably should have figured out how negotiation works, but I'm going to explain it to you anyway, because you seem not to know for some reason. In a negotiation, there's compromise, right? One side gives something, the other side gives something, right? You want something more of something else, you take less somewhere else, right? It's two sides trying to strike the best deal, and you can't have that. In any event, it cannot be the case that an extensively negotiated deal only qualifies as a defense if the employer offered literally the exact same package in their comparator. Male and female employees often negotiate salaries with their mutual employer at different times. Requiring the employee to offer every permutation to all employees, just in case one deal ends up being more lucrative for the opposite sex down the line, would be impossible. It would also be futile. Plaintiff's legal theory, after all, does not turn on the offer of the deal. It requires employees to agree to an identical deal. Therefore, there can be no bargaining. Right? You can't have bargaining if you must agree to the same deal. There's no space to bargain. There's no space to bargain because you have to take the same deal. Yeah. So, which one do you want? This is not a hypothetical concern. Soccer Federation is currently in the process of negotiating new collective bargaining agreements. Based on plaintiff's position in this litigation, echoed in amicus briefs filed by the Men's Association, the Soccer Federation has offered women the exact same deal as the men. But now what? If the women's team wants to negotiate further, or the men's team does, the Soccer Federation is faced with two equally unappealing options. Either refuse to negotiate a different package and risk an unfair labor practice charge, which, or agree to different packages and risk an equal pay lawsuit. Right? Plaintiff amicus offers another option. Have one union represent both teams. That would be fine, but this is not a decision for Soccer Federation to make. They can't do anything like that. They can't even really suggest it, right? The labor law, when you have unions, the labor law is pretty clear. Like, management can't interfere with the union, and any sort of meddling of any kind is mucho bad. So it's probably illegal. It's probably illegal for the Soccer Federation to say, maybe the men and women should have a common union. It's probably illegal for them to say that under the labor law. So it's definitely, very much definitely, not the Soccer Federation's decision to make. Not only is it not their decision to make, they're severely hampered from even suggesting it. As the AFL-CIO emphasizes, collective bargaining has been hugely instrumental in achieving pay equality. The Equal Pay Act should not be interpreted in a way that would take this bargaining away, which it would have to. It would require a women's compensation agreement to be a carbon copy of a men's, or would compel separately represented teams to bargain as one. Plaintiffs should be prepared to tell the court if this is the outcome they want. Right? Put up or shut up, right? Is this really what you want? Really? Are you sure? Really? You really don't want to have the power to negotiate. You really want only one union. If that's what you want, please tell the court. Tell them. Tell them that's what you want. If this is what the law requires, The Soccer Federation needs to know, as does every employee who wants to ensure equal pay. Are we not allowed to have multiple unions? Are we not allowed to negotiate? Please tell us what to do. Please tell us what to do. Title VII incorporates EPA's affirmative defenses. Like the EPA claim, the court may affirm Title VII on the alternative ground that any pay differential was based on a non-sex factor. Plaintiffs are also wrong, however, to argue that any violation of equal pay is also a violation of Title VII. That's wrong. It would be true the other way around. But because Title VII requires the discriminatory component, right? A violation of the EPA Act the Equal Pay Act doesn't necessarily, it doesn't necessarily imply, because the Title VII has an additional factor. This court held plaintiff offered sufficient evidence to defeat summary judgment of EPA claim, but still affirmed summary judgment on Title VII disparate treatment. Title VII claim failed because the plaintiff was not similarly situated to her male colleagues. They had renegotiated their salaries upon receiving competing employment offers, and she had not. So too here, the women's and men's team were represented by different associations that differently paid structures. And a different case rebuts the notion that plaintiff's Title VII claim should automatically survive summary judgment if the EPA does. That's true. It's not automatic. I agree. It's not automatic. But it does require analysis. To the extent that EEOC guidance suggests otherwise, is contrary to the law of the circuit. Well, I thought this was very, very good, all things considered. But I was, as we noted, very disappointed in the complete lack of Title VII analysis, which is what I was all excited for as a legal educator. I was all excited to see some Title VII analysis. And I got F all on Title VII. I got 3 pages. And I got like 46 pages on EPA. I got 3 pages on Title VII. This is not helpful to any of us. So I suppose, for want of a better rebuttal from the Soccer Federation, I have no alternative but to stay where I was. I mean, the Soccer Federation offered me F all. I can't change my mind based on the nothing. So, yeah, I guess I have to continue to conclude that women have a decent shot at the Title VII, because I mean, the men decided not to argue that for some reason. So, okay. Yeah, there was a Title VII argument. It was 3 pages long, if that. It was short. Would you like to go through the entire Title VII legal analysis again? We can, because it was really short. Let's go through the entire Title VII legal analysis again, because, 3 pages. Maybe it'll make more sense the second time. Hold on. And we scroll and we scroll and we scroll and we scroll. Okay, great. We're going to do the entire Title VII legal analysis again. Title VII prohibits employers from discriminating against any employee with respect to her compensation, terms, conditions, or privileges of employment because of such individual's sex. Like the Equal Pay Act, Title VII prohibits paying an employee less because of sex, among other things. Unlike the EPA, Title VII requires proof of discriminatory intent. So yes, you don't have to prove intent under an Equal Pay Act claim. You do have to prove intent for Title VII, which is why a violation of EPA cannot necessarily imply a violation of Title VII. Plaintiff's theory of Title VII pay discrimination was the Soccer Federation paid them less than similarly situated male players, that there was a disparity of wages between the two teams. This court held squarely that when a Title VII claimant contests that they've been denied equal pay for substantially equal work, Equal Pay Act standards apply, which seems slightly strange as a proposition. I mean, does that really mean what it purports to say? Like, if Title VII contends equal pay, or denied equal pay for substantially equal work, Yeah, I guess, well, that would be correct, because I guess it's necessarily true, because if a Title VII complainant is only contending they denied equal pay for substantially equal work, it must be an Equal Pay Act claim, because they're not arguing discriminatory intent, which is Title VII. So yes, I guess that is correct. So it does mean what it's saying. It's just, I read it wrong the first time. So yeah, if all you're arguing is different pay for different work, then EPA. You can't make Title VII because you're not arguing the intent. Okay. These standards require plaintiffs to bear the initial burden of showing. Among other things, the pay of men and women were unequal, or other things. So the district court correctly concluded the absence of evidence of unequal pay likewise foreclosed Title VII's pay discrimination claims. Plaintiffs' arguments to the contrary lack merit. They argue that Title VII is broader than the EPA, which is because it covers more stuff. It covers things other than just compensation, which is what the EPA covers. But the Supreme Court held in a case called County of Washington that it holds that a Title VII wage discrimination claim may proceed even if the plaintiff is unable to point to a male counterpart performing equal work. So you can argue Title VII for discrimination even if there's no men being paid, right? Because Equal Pay Act necessarily requires there be someone of the opposite sex to complain to. So Equal Pay Act requires equal pay among men and women, right? Title VII prohibits discrimination on the basis of sex, which isn't quite the same thing. So if, for example, only women are employed, for whatever reason, if only women are employed, they can't point to a male counterpart for the EPA. But they can argue Title VII because they say, well, we're being paid less because we're women. It's tenable. It's possible, right? Right? Maybe if they did have men, they pay them more. It's arguable. It's possible, especially if there's some sort of, smoking gun emails. That would be great, but it's possible. The EPA claim did not fail because they're unable to show the men's team performed equal work. The Soccer Federation does not contest that element. Yeah. Their claim failed because they could not establish the pay in the men of women are unequal. Plaintiffs cite no case in which an EPA case failed because the plaintiff was paid equally or better, and yet Title VII was paid on pay disparity. Here, too, plaintiffs emphasize the direct evidence of discrimination, which they're not going to mention, incidentally. But even if the Soccer Federation statements betrayed discriminatory intent, they do not. Plaintiffs still need to establish they suffered adverse employment. The statements cannot substitute for showing that they were paid unequal. So their entire argument, which is a little weak, might be legally correct, but it's weak because we just read the entire thing again. It was 3 pages, right? That was all of it. There is no more. That's the entirety of the analysis. That was short. So their argument is even if we had discriminatory intent, so even if we hated the women, it doesn't matter if we didn't in fact treat them worse. If we didn't discriminate against them for like pay or compensation or other thing, the fact that we're women haters is irrelevant. That might be legally correct. So maybe the district court's right. Maybe the Soccer Federation is right. But it's short, it's weak, it's very underdeveloped. I'm not 100% sold. So I know. I was hoping for a lot more, and I didn't get a lot more. So I am disappointed. Let's cover some questions from the bot that you guys have been asking along the way. A. Hedinger said, or maybe COVID could happen. Yeah. Peter Siegel said, out of curiosity, do we know the total compensation of the women's team during the pandemic? Well, you could do the math, but let's see, because they had 30 players, I think. So it's 30 players at $100,000 plus their salaries from the soccer league plus benefits. So it wasn't bad. Peter Siegel said, but them stealing from the men's pool also wouldn't work. Since the men earn more and paid less in total and on a per game basis. Stella said, intelligence and wisdom are their dumb stats. That's cute. Internet commentator said, in some cases, if I recall correctly, in some cases that wasn't always the case, right? I don't know what you're referring to, so I can't comment. Internet commentator says, because mean for a but-for cause, like Title 7. Yes. Yeah, it means for a but-for cause. Or no. It means a cause, which I suppose is but-for. Yeah. But-for is cause is also saying a cause. Yeah, but for them being women, we wouldn't have treated them this differently. Which is the same as saying, because they're women is one of the reasons we discriminated. So yes, it's a but-for cause, which means it only has to be a cause, not the dominant cause or principal cause. Just a cause will be fine. Peter Siegel says, well, an interesting thing was they point out in 8 Stream was it depends on how you define rape. Yeah, the statute did that at least in part. Stella said, stop mansplaining. They didn't seem to understand how negotiation works. So Riley said, we all know Black's Law Dictionary is the ultimate authority. Q. Internet commentator says, unless it's manifest plain error. For facts, yes, that's true. But that's not what they're arguing. They're trying to provide new facts, which is a no-no. Right? They're not trying to argue, here's some facts we had. The district, yeah, they can't bring in new facts to appeal. So what I said was correct. Even in the case of manifest plain error, it's correct. You can't bring in new facts. What you can do is you can say there was manifest plain error when the district court found this fact instead of this fact, and here's the fact in the record, right? On page whatever. Here it is that the court should have found. You can do that. What you can't do ever, ever, ever is bring in new facts. Manifest or plain error or anything. You can't do it. You can't bring in new facts. No, the record is done. You can't bring in new things. Becky says, what area of Title 7 do you want the defense to dig into? I just wanted a more thorough analysis all out, man. I wanted more than 3 pages. I mean, it's so conclusory and so short. We had 46 pages of analysis, or 45 pages, or whatever it turned out to be, on the EPA claims, arguing it 8 different ways, and then we had a total of 3 pages of Title 7. How am I supposed to get my Title 7 fix through 3 pages? It's like, you got any more of that Title 7? You got any more of that Title 7 stuff? I need that Title 7 hit in my life. Any of you guys out there know a dealer where I can get some Title 7? Yeah. It was yeah. So they might be right. It's just very short, very conclusory, and very annoying. I wanted more. Maybe there is no more, but I wanted more. The women's argument is more persuasive, even if the men's argument is technically correct, which it might be. But internet commentator says, has a psychological addiction to Title 7 analysis. I'm telling you what, man. Could some of this be to drag out them getting canned? I don't know. Yeah, I don't know. So, I guess my analysis must by necessity be where we started, which is very disappointing. Very disappointing. I think the women have a tenable chance at Title 7. I think it's possible. The men's argument might be legally correct. Maybe it is legally correct. Maybe the Court of Appeals will agree with the men's argument in the day. But the women's argument was more persuasive. It was better drafted. It was better argued. And there's a tenable chance. But I'm telling you right now, if the Ninth Circuit Court of Appeals reverses on the EPA, I'm going to lose my shit. I guess that'll be good content, though, so they got that going for me. JBoss199 says, if you need a dose of Title 7, you should contact Gloria Albright or whatever that ambulance chaser's name is. Yeah, so that'll be a fun stream if they rule against me, where I'm probably tearing out my hair and, going through some sort of mania or something at the time. That should be really entertaining for my mental health. Banging head on wall is a distinct possibility. Banging head on wall is a very distinct possibility. All right. Well, We had fun anyway beating them. We had fun beating them to death on the EPA claims, so that was fun, at least. So we had some fun along the way, even if we didn't get as much legal analysis as I hoped. But that's all for now. If you've enjoyed this stream, where I've been streaming for how long have I been streaming? 2 hours and 14 minutes for you guys. So, trying here. If you've enjoyed this stream, please remember to give it a like. If you're not subscribed already, please remember to subscribe. And did you know for 99 cents, you can become a member of the channel? It's true. You click on the little join button, or you click on the link that Nightbot is telling you about from time to time. And you can join that way. It's only 99 cents. And then you get a little cool icon by your name, like Eddie Hedinger and Internet Commentator and Zulu Zit. You get that little cool Scales of Justice thing. That's cool. And you help the channel financially and support it, which is awesome. I really appreciate all my members and all my subscribers. Until later, my friends, I hope all is well. Cheers and goodbye.